Good morning and welcome to this UK-India Business Council webinar on Indian employment laws, featuring an expert from NC Legal. My name is Stuart Muir. I'm a Regional Business Advisor at the UK-India Business Council, and I will be moderating this session. Today our speaker will share advice on one of the foremost topics that comes to mind when choosing to set up a business in India, that of employment law. This session is part of our Access India webinar series, a program designed to support UK businesses through short online sessions on a variety of topics. Before we begin, I would like to familiarise you with the toolbox on the right-hand side of your screens. Just to let you know, we will have everyone on mute during the course of the webinar to keep any background noise to a minimum. But if you have a question, please drop it into the little bracket on the toolbox on your right in the Please Type Your Question Here box. That will send me the question and I'll take it up during the Q&A session at the end. For now, to make sure that you can all hear me clearly, could I please ask that you use your Raise Your Hand button on the toolbar. Please could you click Raise Your Hand. Okay, thank you. I would now like to welcome Shalini Agarwal. Shalini advises on Indian employment and immigration law. She services multinational clients from all over the globe. Recognized by international law organizations as a leading lawyer in India, Shalini is a partner at NC Legal, an Indian law firm with offices here in the UK. Over to you, Shalini.
Stuart, and welcome. Welcome to all attendees. It's my pleasure to talk you through some of the salient issues that come up for consideration when you talk about employment law, HR, and so on. I think before we kick off, one issue to bear in mind is that India is a unique environment that you are dealing with. You have to expect the unexpected. You need to know that HR, employment issues are not standalone issues and have to be dealt with bearing in mind the cultural environment that you're dealing with. So starting off with the first slide, a quick overview perhaps on what it means to be operating in India and how that can impact some of your HR considerations as well. So we consider India a quasi-federal legal system, which basically means we have one federal law that applies across all of India, but we also have state-level legislation. So it's important to ensure that when you're doing business in India, you're compliant both at a federal as well as state level. Especially when it comes to employment law, states are authorized to regulate on employment law issues and there are state-specific compliance requirements. So again, for a UK company that's operating in India, it's important to ensure that they tick the boxes for not only federal law, but each specific state that they might be operating in, and there may be variations between these states which have to be factored in. So that's a key aspect. As I mentioned, employment law, HR is not a standalone issue. Typically, you need to look at the tax implications, immigration considerations, and also consider the regulatory environment that you're dealing with. So again, a first step very often is to make sure you are clear about what your corporate structure is, what your objectives are in terms of what you're trying to achieve on the ground, and ensure you deal with the HR and employment law aspects in tandem with these other issues. India has liberalized a lot. It's an investor-friendly regime, but it still remains regulated. There's still a lot of bureaucracy, and it is complex. So again, it's important to ensure that you educate yourself on the market before you dive in there. The cultural aspects cannot be underestimated. I think the need and the success is very often based on effective communication. And that means, strategically thinking through how you would deal with issues on the ground in India, as opposed to perhaps, in the UK. The fact that Indian law is based on English common law is a matter of great comfort. But at the same time, I would urge caution, because while it's similar to English law, it is not English law. And that is sometimes where companies fail to see the necessity to adapt their contractual documentation or perhaps the way they operate to suit Indian requirements. There also has to be a recognition that India is very large. Next slide, please. Just again for a quick, sort of reminder on the, the size of the country. 29 states, 1/3 the size of the continental U.S., very diverse, lingually, culturally, and so on. So that again means you have to be aware whether you're dealing with employees in metropolitan cities, whether it be Delhi, Mumbai, Bangalore, Chennai, or you're dealing with employees in smaller cities known as Tier 2 or Tier 3 cities. Because again, the recognition of sort of HR style, sort of Western style HR issues will be more limited in smaller cities. So the sort of strategies you have to put into place in these cities will be different to perhaps sort of the larger cities where you might find employees who are more sort of au fait with international styles. Also, it's very important, next slide please, to bear in mind that when you start, considering operating in India, that you look at exactly what your corporate structure is. Very often I find HR come to us not quite understanding perhaps where their business operations are at, whether a subsidiary company has already been established or whether it's in the process of being set up, what the time lag is, whether they can actually employ somebody whilst the structure is still being put into place. So again, getting the sequence right and ensuring that you have the right, operating entity on the ground becomes very important. Similarly, when you're looking at actually recruiting or sort of employing an individual in India, there are very different ways you can do that. It could be by virtue of an assignment or a secondment, or you might have a local employee who's coming on board. Again, these terms very often are used loosely, but they all have legal ramifications. So again, taking one step back and saying, okay, I need to employ a certain individual in a city for our business operations has to be based on exactly the structure that is in place and the objectives to be met. In some instances, a consultancy arrangement might be more appropriate if, for example, your subsidiary company has not yet been set up, but you found someone who's suited to need, but it's going to be some time before you can actually employ them through your Indian entity. So again, it's important to ensure you have the right contracting parties in place. Also, immigration never used to be an issue until a few years ago, but now it becomes critical to assess if you're sending someone from overseas, whether that individual can actually, get the requisite paperwork, the employment visa, to work in India, or whether what they intend to do is, would suffice them going out on a business visa. There are very clear sort of guidelines by the government now in terms of what qualifies for an employment visa, what qualifies for a business visa. So again, something that needs to be ticked off right at the outset and not left to the end. As I mentioned, India is investor friendly, but we still have a lot of regulations, and there are foreign direct investment rules. So again, depending on the sector that you operate in, the industrial sector, it will be very important to ensure that your employee going from overseas can actually do what he is being hired to do, and that no additional or prior approvals are required before that individual gets going. Tax liabilities are determined pretty much on the basis of residency, so how many days someone spends on the ground in India. And there are, of course, both personal and corporate tax sort of ramifications that have to be factored in. Again, this is something that from an HR perspective should be taken on board at the outset and perhaps dealt with before or at the same time that you're putting in systems in place. Moving on to sort of, the final point on recruitment, what sort of starting point really is documentation. This gets confusing for a lot of international companies if they are being led by local HR managers or local management that don't always see the necessity and the importance of ensuring that you have all the paperwork that is aligned and is not contradictory or sort of half-baked, so to speak. This means you need to know what you're offering, so an offer letter is a good starting point. You also need to consider, what your employment contracts, sort of should look like in terms of what you're offering. At the same time, they must be compliant with local Indian law. So again, a good starting point is to take your UK or your global employment contract, but make sure you adapt it for use in India, which means compliance both with central and local laws in terms of terms and conditions. Equally important is to consider your exit strategies whilst sort of considering recruitment. So the question really is, what do you have in your contractual documentation that would entitle you to part company or would facilitate that process should you come to that point? So again, moving on to the next slide, it's important for you to know that India actually has a statutory enactment, the Indian Contract Act of 1875, that regulates all sort of all contracts of employment. So again, whatever you contract, with employees for will be sort of interpreted and regulated by this contract to a large extent. So again, it becomes quite important to ensure that you have all the required contractual arrangements in place and leave little room for ambiguity. By the same token, what comes up as a challenge for UK companies is to know that what they consider boilerplate standard clauses are often not enforceable, in India because of local law. Two such boilerplate standard clauses that do cause some concern, for example, are the non-compete clause, which, as you know, a restrictive covenant to stop an employee from joining a competitor. So again, under Indian law, there is a sort of a restriction on prohibiting an employee from earning a sort of livelihood, being able to sort of continue to work beyond their employment with you. So again, drafting or including a bog standard non-compete and aiming to rely on it on a court of law will not achieve the objective that you may wish to. So knowing that upfront, there are other sort of things that you can take into account to ensure you safeguard your confidential information, knowing very well that you can't really stop an employee from leaving and joining a competitor or within a couple of days of that person leaving your employment. Non-solicitation clauses, again, have a similar treatment when it comes to non-solicitation of clients. There has been case law to suggest that just having a database or a client list would not per se entitle you to, restrict an employee from approaching those same clients. Non-solicitation of employees, becomes more enforceable as long as you can actually prove that the employee did not leave voluntarily and was actually solicited by your ex-employee. So again, the onus of proof, the burden is very high, which makes it very difficult in effect to enforce these very important clauses. Similarly, Indian courts are not prone to give penal penalty clauses or enforce damages beyond actual loss. So again, building in very onerous penalty clauses becomes redundant. Having said that, companies do retain all of these clauses because they do have a deterrent effect, but you need to retain them knowing very well that you may not be able to enforce all of them to the extent that you are able to in the UK. Finally, when you're doing, contractual agreements and, offering other terms and conditions to employees, it becomes important to ensure entitlements for employees and what actually, may be over and above the mandatory entitlement. Leave, for example, causes a lot of confusion, holiday leave entitlement, because this can vary amongst states. So depending on where you're operating or where your employee is based, if he's a remote worker, you may need to adapt their contracts of employment accordingly. Similarly, we have severance payments that might be applicable to certain categories of employees. Again, when you're recruiting, it's important to know that we have quite a unique feature in Indian law, which is categorization of employees as workmen versus non-workmen. And the term is a bit misleading because it's nothing to do with skilled or unskilled. The basic sort of takeaway is that if your employee is not in a managerial, administrative, or supervisory role, then most likely that employee is going to be a workman, which means that they're entitled to additional statutory protection when it comes to terminations, exits, grievance procedures, and so on. So again, up front, it becomes very important to ensure you're clear about the category of employee that you're dealing with as well. On to the next slide, please. Dealing with retention, again, I think in India a lot really, depends on, dealing with the local culture in place. Very sort of patient but firm approach is required when dealing with local employees. I think working with idealism and not against it perhaps can help achieve a lot of successes. The basic, I think, point is that if you have your contractual entitlements and obligations clearly laid out, it's transparent and it gives visibility to both employees and to you as an employer in terms of what you're offering and how that can benefit both the company and the employee. Employees lay a lot of worth on work-life balance and what they perceive to be a good working environment. And the loyalty factor in India is quite high. Once an employee does subscribe to the company, or they are happy in the environment they are in and build a relationship with their peers as well as their superiors, that loyalty factor can go a long way in helping with retention and dealing with irritations within the business. That also means having good policies in place. That's both in terms of safety, for example, ensuring that you have the right mechanisms in place to deal with, for example, prevention of sexual harassment in the workplace. Not only is that a good policy to have to ensure that women employees, female employees benefit from the work environment, but it's also a mandatory requirement of law to ensure that you not only have the policy in place, but you also have the committees and the right processes to deal with issues. And this is irrespective of whether you actually have female employees at the moment in your Indian operations or not. So this becomes an important aspect as well. So finally, I think when you're talking about retention, as with everywhere else, ensuring a good work-life balance, appreciating cultural differences can go a long way in helping you meet your requirements. Moving on to the next slide, please. Talking about, terminations and redundancy, it's unfortunately a reality that, if you are doing business in India, you will come up against situations where you will have to terminate employment, or you have employees who are choosing to leave. So again, this is where it becomes really important, again, to ensure what your obligations are, both in terms of statutory and contractual obligations towards the employee who is going to be leaving employment. So again, the distinction between workmen and non-workmen becomes really important when dealing with a termination scenario. The IDA, the Industrial Disputes Act of 1947, that's pretty much like the Bible of Indian employment law that sets out, very exhaustively terms and conditions of how you deal with grievances, how you terminate, and so on. So again, if you have an employee who is within the category of being a workman, non-managerial, non-administrative, non-supervisory, it becomes important that all your termination processes are aligned to what the IDA says and all the rules that are prescribed thereunder. If, however, your employee is not a workman, then it becomes really important to ensure that you abide by the rules and procedures laid down, or the contractual arrangements that you have in the specific employment contract, as well as your policies. So that's where, again, it becomes important to ensure that you have actively put in place proper grievance redressal, as well as termination policies for your Indian employees, so that you know exactly what path to follow when it comes to that. Moving on to the next slide, please. Again, to sum up, so dealing with terminations, you can have termination for cause. It could be misconduct. Again, if you have an employee who is a workman, there will be local state laws that would prescribe what constitutes misconduct, or if you have your own handbook that would have clearly provided what activities might amount to misconduct, and in certain instances employers may need to have their handbooks certified by the local labor authorities to ensure that they are compliant and can enforce those terms and conditions in their handbooks, in which case if there is a termination for misconduct, you then have to follow the sort of process that has been set out by the local state authorities. And that includes, having your internal committee for handling, the hearing, making sure you take all the prescribed steps in issuing the notices and giving the employee a fair chance to defend their case. If you have an employee who you're terminating for misconduct who's not a workman, it boils down to what your contract of employment says in the handbooks again. So it's very important to ensure you not only have these sort of arrangements in place, but you know exactly what these arrangements are in good time before you trigger a termination. Also, in terms of exit, I very often tell my clients that it's important to look at things from a helicopter sort of perspective in what is the objective trying to be achieved. In certain instances where you have to showcase a termination for wrongdoing, yes, you have to take a stand and you have to trigger the termination. In other situations, you're looking to diffuse a situation and just, exit the employee with a minimal fuss and disruption to your local operations. In such instances, it's worth considering if you have other options and opportunities, or whether the employee himself is willing to resign and leave. So again, from a strategic point of view, it's important to ensure you consider the local cultural environment before triggering your legal entitlement straight off. Where you have a termination for no cause, retrenchment, that's sort of the Indian term that's used, that pretty much means a redundancy, where you want to let go of an employee for no wrongdoing or for no cause at all. There again, you have certain statutory obligations towards the workman category of employee. So you will have to pay, in addition to your notice pay or to your contractual obligations, additional severance payments to this employee who you're letting go. So, and in certain states, you also have to give some reason, even if it's a termination for no cause. So again, the basic takeaway is that when you're dealing with Indian employment law and Indian termination issues, it's important to step back and ensure that you've met, federal, state level sort of requirements, but you're also looking at it from a sort of cultural perspective to see where you can make sure you get your objectives met with the maximum ease. So just the final slide really is a quick checklist for you to look at, if you're considering a termination, what you should be doing pre-termination before triggering, the exit, and how best you can manage the process once you get there. So that really was a quick bird's eye view on some of the issues relating to, sort of hiring and firing employees in India. I'm happy to take some questions, if there are any.
Thank you, Shalini, for the insightful presentation. We've got one question through from the delegates. Are there standard type employment contracts available as a starting point which covers the legal requirements for an Indian employee?
Right. You won't find standard employment contracts online or through government outlets. What the local state law prescribes is that employees should be given some form of terms and conditions, appointment letters as they're often referred to in India. If an employer does not sort of provide that in writing, then sort of the local sort of prescribed terms and conditions would sort of apply to that employee on the ground. But a good starting point would be to use your sort of UK contracts and strip them down for use in India. Again, very often I'm advising clients that it's better to take away what's additional and extra and what's not needed in India than to leave it in there, because that causes a problem for clients later on.
Somebody's asking whether they can have a copy of the presentation.
Yes, by all means, that's not a problem. If I'm happy to provide that. If you'd like to email me, or if they'd like any more information, very happy to share that.
Okay, so that goes for anyone really, doesn't it, that wants to have a copy of it?
Yes.
Yeah. When setting up an Indian business or subsidiary, what would be the capital investment required? And that might be outside of the scope of this particular presentation, actually.
Yeah, I'm happy to take that offline.
Look up in more detail. Yeah, I think so. Somebody's saying, can we have the email ID of Shalini? Yes.
Yes, it's on my last slide as well.
It's on your last slide. Yeah, there we go. Yeah. If you want to take that down, folks. Are there any more questions? Any more questions? No, I think that appears to be it. Thank you very much.
Thank you, Stuart. Thank you, Rebecca, for arranging this. It's my pleasure. And as I mentioned, if any delegates listening in would like to sort of run, any specific queries they might have by me, I'm very happy to entertain a sort of initial no obligation call or email communication.
Thank you very much. Thank you. Thank you for your time, and I hope that this webinar was valuable to you. If you have any feedback or comments about today's session or a session that you'd want to see us do in the future, please feel free to get in touch. I would like to invite you to visit our website and check for the other webinars that we are organising as part of our Access India series. Thank you for joining.